evening. Welcome to the Select Committee on Science and Technology. We're undertaking an inquiry on forensic science and the criminal justice system, and we're very pleased to welcome as our witnesses Sarah Sackman, KC, MP, the Minister for Courts and Legal Services in the Ministry of Justice, and her colleague Christina, Deputy Director, Criminal Appeals Policy and Miscarriages of Justice. So we're very pleased to have both of you here. I would like to start, and as you both know, this inquiry is following up on an inquiry we previously did about 7 years ago. And what this is really all about is to ensure that there is a properly functioning forensic science system, which I think we all agree is critical for the effectiveness of our criminal justice system. And yet, responsibility for ensuring we have this seems to fall between the 43 police forces, the regulator, the market, the Home Office, the courts, and indeed the Ministry of Justice. And as you know, we spoke to the Home Office Minister, Sarah Jones, last week, and she made it very clear that the Home Office takes the lead in responsibility for forensic science system. But we are concerned that the Ministry of Justice should have a significant role to play in forensic science in the UK, obviously because it concerns the defence and achieving criminal justice. So perhaps you could start by setting out for us what mechanisms exist for you to coordinate with the Home Office and ensure that the Ministry of Justice has a real voice in this area. And there used to be, as you probably know, a forensic science steering group. And our question really is, are there any active coordination mechanisms that exist now? So perhaps, Minister, you could start, and then Christina, you could also chip in as and when you feel is appropriate. So, Minister.
Well, let me say, Chair, in opening that I really welcome the work of this committee. I think in shining a light and providing scrutiny on how forensic services operate in this country, the committee is performing a really vital function, and I think the continuity with the work that the predecessor committee performed in 2019 is really vital, because it shows what progress has been made, where that progress has been lacking, and I think in bringing together the various witnesses, it provides some impetus for both evidencing but also building upon that cross-departmental work that's necessary. You're absolutely right, of course, that the Home Office Minister, Sarah Jones, was correct in saying that the Home Office properly leads on this. And in terms of the wider reforms to policing that the Home Office is currently undertaking, it's right that the responsibility for funding, for the regulatory framework that governs forensic services, that the Home Office takes the lead. But you're also right that the Ministry of Justice has a part to play in this, and our role in this, I think, is threefold, perhaps. Firstly, in terms of our responsibility to the proper and fair operation of our court system and the way in which forensic evidence can support that. And so ensuring that the system is sustainable, that it operates fairly and with integrity to support the achievement and determination of just outcomes in criminal trials is vital. Secondly, in terms of the relationship the MOJ holds in terms of funding the legal aid agency and the way in which that supports the funding available to defence solicitors in terms of engaging experts to provide that evidence to the criminal justice system. And I think, thirdly, in terms of our wider set of relationships that we hold responsibility for with the independent judiciary, with the CPS that of course operates independently of government, but where we hold those relationships and so we can assist and support Home Office in that coordinating function. And so to sort of conclude my opening before I turn to Christina, I think where, as a still relatively new government, although we can't rest on that fact for all too long, the work of this committee is so valuable because I think what it's done is, whilst that reform to policing, in conjunction with the reform that is taking place within the criminal justice system and the transformation programme that is being undertaken in the legal aid agency, that we don't neglect this very important issue and ensure, and where necessary strengthen, the coordinating mechanisms that there are between our department, Home Office and other criminal justice partners. So thank you for shining a light on that, and I'll turn to Christina to explain in more detail what coordinating mechanisms there are.
Thank you. Yes, so my team is the team responsible for ensuring that the voice of the defence, the courts and the judiciary is heard in the work that the Home Office is doing. I sit on their steering group, and officials in my team sit on the groups that sit below that at working level. I work closely with the Home Office, albeit I'm relatively new in post, so have recently started building those relationships. But I spoke to Christoph Prince last week, and I've spoken to the new National Forensics Director as part of a wider meeting just before Christmas. So I'm building those relationships at the moment, but I sit on the relevant steering group, and the team are responsible for engaging with Home Office on this.
And how long have you held the position you currently have?
I started before Christmas. I think it was the middle of November.
So pretty recent?
Pretty recent.
Okay, thank you. Baroness Young.
Thank you. We've had evidence from the Westminster Commission on Forensic Science, drawing on the report that they produced, highlighting some of the issues in forensics in June last year. They've not yet had a response from government, though when we spoke to Sarah Jones last week, she said she had read the report. Is that a report that you have drawn on and studied for your aspects of oversight of the forensic science system?
Just to check that you're referring to the report that was produced by the APPG for Miscarriages of Justice?
Yes.
Yes. Yes, I'm familiar with the report, and in particular its findings and recommendations as it pertain to matters concerning the Ministry of Justice. And I think those broke down into two areas, one of which I failed to mention in my opening response to Lord Mayor, and in addition to what it highlighted around the legal aid agency and its role in ensuring, broadly speaking, parity of arms as between prosecution access to forensic experts and defence access. There were, of course, the recommendations in that report in relation to miscarriages of justice and the role of the CCRC. So I suppose the short answer is yes, familiar with that, and our responsibility in relation to supporting the work of the CCRC so that it can embed forensic services and science into its re-investigations and look into miscarriages of justice. That's really important, and I think some of those recommendations have already been taken forward in terms of the approach that MOJ government is giving to the CCRC under its new leadership.
So will you be making a response to the report, or does that not happen because it's an APPG?
I don't know that we would routinely make a formal response to an APPG report. That's not to minimise its value, which, as I said, has been taken up within the department and acted upon. So just to give you an example, we may come on to this, but the programme that we're funding within the CCRC, the Forensic Opportunities Programme, and the wider work that we have been encouraging within the CCRC draws inspiration, if you like, from that report. So whilst we haven't provided a formal response, that certainly doesn't mean that we are passive or dismissive in relation to its findings, far from it. I think insofar as it builds on the report that this committee produced in 2019, it's of significant value in terms of adding to the nation and Parliament's understanding of where forensic services stand and where the shortcomings in the service lie.
We've tried hard to find a minister who's got the word forensic in their portfolio description, and there isn't one. Do you think there should be one, and where should it be? That's
a good question, and quite possibly, actually. I'll be completely candid with the committee that I'm the minister with responsibility for courts, and so questions around criminal law policy, the interrelationship with the legal aid agency and legal aid policy, for which I'm responsible for, clearly bring this area within scope. But I think that quite possibly specifying forensic services as lying within a particular minister or minister's portfolio would be of assistance, because I think it would draw additional focus to an area which can, incredibly important though it is, can get subsumed within other areas. So I think it's a great question, and I think it's something that could be of value. The first thing one does when one comes into any ministerial role is look at the long list, in my case an incredibly long list, of things that come within your portfolio, and then you decide how much time you can allocate to each of those things. You can't give everything equal priority. But I think the omission of such a label perhaps speaks to the relative lack of focus that this area has received from successive governments. So it's a really good question.
Lord Brayson, you want to come in?
Just building on that point, Minister, your responsibilities do include responsibility for the Ministry of Justice role, your mission to kickstart economic growth. Now, we've heard that the provision of forensic science services in the private sector is in crisis. So within that context, do you feel a responsibility?
First and foremost, I see my responsibility in relation to forensic services as being one of justice and fairness. It's about supporting just outcomes within the criminal justice system. I don't see it as a growth measure, although it may indirectly support economic growth if we have a sustainable and dynamic sector and market. But primarily this is about getting it right, ensuring that there's fairness and parity between different sides in the criminal justice system. It's about getting to the truth. And so that's my focus. Is there an adequate supply of expertise? Is it properly funded? Does it operate within structures that are supportive of fair outcomes? That is my focus. I don't look at this as I do perhaps parts of our legal services industry with which have a more commercial bent, and where we're looking at, for example, as we have done, updating our arbitration legal framework to make us more competitive with international jurisdictions. That's where I focus when I focus on growth. With something like this is about evidence in criminal trials. It's got to be fair, it's got to be sustainable, it's got to be retained in a proper way so that if there are questions over whether justice has been properly administered, cases can be reinvestigated in a proper, fair and timely fashion. That really is my primary focus, not growth.
That leads very naturally on to the question from Lord Burnett.
Yes, thank you. Well, good morning, Minister, and good morning, Christina. Christina worked in the Judicial Office for many years, and so we know each other well. Could I start by saying I have to leave at about 10 to 11 for another committee, and there's no discourtesy intended.
None taken.
In your answer a moment ago to Lord Drayson, you indicated that you regarded it as part of your function to ensure an adequate supply of forensic scientists, so that's across the range of disciplines that are needed in cases, and also that they're properly funded, and that is for the context of the defence. Now, of course, the prosecution through the police and also through purchasing from private suppliers have access to forensic scientists, and the arrangement for defendants is more ad hoc, if I can put it that way. Unusually, we've had a unanimity of view in the evidence before us from lawyers that the arrangements for defendants are inadequate and lead to inequality of arms, from academics who train forensic scientists that that is true, and also, as it happens, from the main commercial supplier of forensics, that there is inequality of arms. And there is a concern that's been expressed to us that because of the ad hoc way in which this operates, there's a danger that it's going to wither, and in particular because the arrangements for paying defence forensic experts are so different from those for paying prosecution experts, often one would hope the same experts. So in general terms, I'd be grateful if you could explain how you are going about ensuring an adequate supply and also properly funded, and perhaps sort of point to the funding in particular. We've heard that the legal aid agency pays only a fraction, over a half per hour of the fee paid by the prosecution for forensic scientists. And so it is no surprise, at least to me, that it's very difficult to secure defence forensic scientists in some disciplines. And I should say, just having recently had my car serviced, a very modest car, I should emphasise, the hourly rate paid to forensic scientists by legal aid is a good deal less than the hourly rate charged by a perfectly normal garage to service a normal car. So, two specific questions: adequate supply and funding, and can you justify the difference in rates being paid by the prosecution and the defence?
So I'll answer that as best I can. I think to start with two, I think, important principles which need to guide our approach to this, and then I'll happily get into the specifics of how much we pay, how we keep that under review, and also the process by which we pay people, because that's also important. As any sole operator or small business will tell you, the timeliness of payments is an important component of the sustainability of any market. It's all very well being paid at X or Y rate, but how quickly you're paid is important as well. In terms of the principles, we've both used the phrase parity of arms. That's not an absolute concept, but in broad terms, yes, parity is important if justice is to be administered on a level playing field. And so the ability of the defence to access forensic experts with the requisite expertise and of requisite quality is important. And that's my second point. In terms of principle, it's got to be about quality as well. We can have lots and lots of forensic experts, but they've got to be up to scratch and capable of meeting the demands that particular case places on them, particularly where we know that DNA technology and others are becoming more and more sophisticated. In terms of the funding, we currently pay experts £104 an hour outside of London, £83 an hour if you're within London. That is based on historic rates which are of some vintage, dating back to 2013, but they reflect a significant 50% uplift that took place when Lord Bellamy conducted his review of legal aid rates across the board in 2022. On paper, and I accept this is on paper rather than the evidence that you've heard, that is commensurate with the CPS guideline rates, which range from £47 an hour to £100 an hour, although we know that in reality the amount paid can significantly exceed that amount. I should also make clear that under the system which the legal aid agency operates, if a case is particularly complex or requires more than that, then applications can be made to the legal aid agency for additional case funding, and on a case-by-case basis that will be granted. I spoke to officials at the legal aid agency, and they told me that they considered that those rates were capable of sustaining the existing market, and that the demand for forensic experts from defence was capable of being met at that rate.
How do they know?
Based on their interactions with providers. They're in constant communication with providers, whether that's through general contract management, whether that's through payments. They'll be speaking to providers, and providers, as is often the case, will say, well, we're having difficulty securing, they might say difficulty securing an expert, or we're having difficulty with X or Y payments, or we need this. They're in constant communication with them. Now, that's not to say that I am dismissive of what this committee is reporting back in its question to me. And indeed, one of the things that, in preparation for this committee, I have said to officials is that it's not sufficient for us to base our view on the adequacy of supply on what providers may or may not be telling us. It's important that within government we proactively seek out views to understand the health or otherwise of the market. So that is something that is in train. The issue that I wanted to...
Forgive my interrupting you, Minister,
of course.
But that's something which is in train. Could you just give us a little bit more about that and what that actually means and when it started?
Well, what it means is that as part of the work that the Ministry of Justice will be taking forward in its conversations with the Home Office, is as part of the ongoing review that we undertake routinely of legal aid rates, that particular focus is placed on the adequacy of the rates that we are currently paying. And as part of that review, I have given the steer that it would be necessary to look at the strength or weaknesses of the market and the ability of the market to meet the demands. Now, as I said, the MOJ and LAA doesn't currently take the view that there are cases where the need for an expert is going unmet at these rates. There is no evidence of that. But what I have given the clear steer is, as part of the general review that we do of rates, and you'll know that we are undertaking and have already begun to take decisions on uplifts in rates for criminal work for solicitors and barristers, that's public domain, that this form part of that. We don't have the results of that yet, and I'm happy to report back to the committee once that work has been completed. But my point is that we don't necessarily accept the conclusion that the need is not capable of being met at these rates. However, I do accept that if you don't ask the question and find out for yourself and collect that data, you can't be sure that you're right about that. I did want to say something about the timeliness of payments. I know that others want to come in, so I can hold off on commenting and address points that may be on this topic.
And so could I just ask one point to clarify? You explained that the legal aid rate for outside London is £104 an hour, and inside London it's £83 an hour.
Yes.
Which at one level seems surprising. Can you explain the thinking behind that?
I agree. I questioned it myself because ordinarily you'd expect it to be the other way around. Yes. For so often one gets London waiting, and I asked the same question myself. And the answer that I got, and I'll give to you, is because there is a greater supply of experts within the London area, the demand is capable of being met at that rate.
I see.
And it may be that outside London, because of a relative paucity of experts and additional travel time and all of that, that's reflected in the higher rate.
Thank you. Baroness Walmersley and then Baroness Northover.
Thank you. Minister, can I just refer you back to your conversation with the Legal Aid Agency? Some of our witnesses might have actually given the response, the Mandy Rice Davis response, they would say that, wouldn't they? Because when a defence solicitor has to get 3 tenders before they can get the funding from the Legal Aid Agency, and then they have to take the lowest one, putting aside the fact that there may not be 3 companies that can give those prices, those quotations, given that one of the external suppliers takes 86% of the market, it certainly doesn't make it easy for defence solicitors to comply with the requirements of the Legal Aid Agency, and it certainly doesn't encourage the market if you're going for the lowest common denominator. And I think we have to assume that all the experts who are taken on to give this advice to the defence are up to the standard required by the regulator. So the situation, although you're saying that there's no evidence that, there isn't enough supply, it's sort of staggering, isn't it? It's only just making it, and it's certainly not encouraging the market.
So, I'm grateful for that intervention, and I think what it touches on is the role that Legal Aid Agency has to play in facilitating access to forensic experts, and indeed supporting the market through its processes, not simply through rate setting. And the area you touch on, the approval process, is one of the areas that has undergone some change recently. So you're absolutely right that formerly one of the requirements that the Legal Aid Agency made on providers was the provision of 3 alternative quotes. That has now changed so that providers are now required to submit their application for approval if it looks out of kilter with usual rates and the LAA's assessment of the market. Then they might be asked to provide one alternative quote, because we recognise that the process that previously existed, which you've described, is cumbersome. And one of the things that I'm very conscious of, before I came to this place, I practiced as a self-employed bar, and undertook some legal aid work. And one of the things I came to understand is that, regrettably, legal aid providers spend so much of their time not servicing their clients, but actually dealing with the administration of their practices, very often generated by the processes of the Legal Aid Agency. So now, seeing it from the other side, one of the things I want to see us do is make that process easier. So that the new approach is about looking at the individual merits of the case and the quote as it relates to that case. And one of the things that the Legal Aid Agency is now doing, as well as not requiring alternative quotes except in exceptional circumstances, is also providing better guidance for how to streamline that approval process for providers, because we recognise that it has historically been unwieldy, and that just simply adds to the cost of doing business. You're right to highlight it, and we've got to look at how we can make things easier.
That's ongoing work. Is there a target for getting it sorted?
So it is ongoing. So we've transitioned to that new approval process, and the implementation, the drafting and implementation of better guidance to aid the approval process is work in progress. I'm not going to put a firm deadline on it, but again, I would say the work of this committee in highlighting the need for it will help.
Minister, just before Lord Burnett has to depart, he has a question about streamlining.
Yes, and I know Baroness Walmsley also has an interest in this. First of all, I need to ask the question: do you understand what we mean by streamlining reports?
Is this the point around the CPS approach of a streamlined report?
Yes, so what we've heard is that in many instances a streamlined report is prepared, which is really a headline summary of the evidence, often without giving any detail of the nature of the underlying scientific investigations, or even indicating who precisely did what. And the observations we've heard really come to this, that it presents the defence with a real difficulty in trying to get behind the streamlined summary to understand whether the conclusions set out in the streamlined summary are valid or should be investigated further and challenged. And this had, so we've heard, a couple of consequences. First is it very much depends on the underlying experience and expertise of the defence lawyer, whether they can see behind what's in the streamlined report. But also the point was made that it sometimes leads to further forensic investigation, including by scientists being paid by the Legal Aid Fund, which turns out to be unnecessary.
Well, I understand the process as it stands, and the Ministry of Justice doesn't decide or determine how streamlined forensic reporting is applied, and obviously we don't make the decisions on an individual level. I think the improvements to the operation of that process, which, stepping back, could have real utility in terms of, well, doing what it says on the tin, I suppose, streamlining the documents and focusing forensic testing where it's really needed. I think that would need to be considered in collaboration with the CPS, which bears responsibility for how that procedure is overseen. And obviously we've got an interest in that to the extent that you've highlighted, because if in fact it's not streamlining it, but it's actually generating additional costs to the public purse and to the legal aid agency, then it's not performing its function. But I would say that it's really a responsibility that lies with the CPS.
Well, I'm sure Baroness Walmsley is going to pursue this a little further, but if everyone would forgive me, I must go now.
Thank you, Lord Burnett.
Good to see you.
Baroness Northover, you want to come in? I think Baroness Young as well, and then Baroness Walmsley.
Yes, and this is taking away from process and back to the level of legal aid. You said in answer to Baroness Young that you'd seen the Westminster Commission report and you'd, in effect, drawn out the things that related to your area of expertise, it sounded like. And then you're also saying that you're not picking up that there is a problem in terms of the funding of legal aid into this area. And yet the Commission notes that the current legal aid rates severely restrict defence experts, making it difficult to provide sufficient assistance, etc., and that there is a risk of miscarriage of justice because of this, and that there isn't equality of arms, which is what Lord Burnett was asking about. So, and that this is that the underfunding on one side compared with the other is a central criticism coming from the Westminster Commission. Yet when you referred to the Westminster Commission, you didn't, it seems to me, adequately address this central part, and you've indicated that your own investigations within MOJ don't bear that out. So I can't see how these two square.
Well, We entered government in the summer of 2024, and zooming out for a moment, we inherited a very difficult situation in legal aid generally. Highly vulnerable systems, which, as you know, have been subjected to a criminal cyber attack, which essentially resulted in the whole legal aid system, digital system, being switched off for 6 months. We kept the show on the road, but I think it points to the vulnerability of the system we inherited. We also know that in civil legal aid, solicitors hadn't received a pay rise since 1996. And in criminal legal aid, the challenges in that area are well documented. So I don't say all of this to deflect from a very, very good question, but I do just put it in context of how we've had to prioritise addressing the challenges at the legal aid agency. And the way I've prioritised it is, one, rescuing the system and transforming the legal aid platform, which we have done. So we've restored the systems and we've built back better. There is more to do, but that will support, I say this because it will have an indirect positive effect on the people we're talking about, the experts in forensics, because it's supporting the providers and their ability to do their work. We've prioritised investment in criminal legal aid for both solicitors and advocates, an additional £92 million on that side, and indeed fee uplifts for civil legal aid. So I have picked my priorities, and it's fair to say that we haven't revisited the rates for forensic experts, and that is in part because I am told that the demand, and it's a very fundamental demand, you need an expert subject to the regulator and their quality requirements to be able to service these cases. And if you look at the amount that we're spending overall, that has remained steady. So we are paying via providers these experts to do this work, and these criminal trials are happening. That's not to say that your observation, drawing on the observation of the Westminster Commission, isn't one that I need to take away and challenge the department and the LAA to look at again. But I do have to be candid that within a tough fiscal environment, we are investing more broadly in the legal aid system, and I've got to pick my priorities. And we've started where we've started on stabilising and rescuing the systems, investing in criminal legal aid. It may be that after this committee reports, I'll have my next priority clearly in focus. But I did want to be candid about the broader challenges, but also the way in which that in itself can sustain the operation in which forensic experts are operating. If I've got a system that's keeled over, or I've got criminal solicitors withdrawing from the market, then that too damages the sustainability of the market in forensic experts and the ability to discharge this vital work in our criminal justice system.
Baroness Young, you want to come in, and then Baroness Walmsley.
Yes, I was very keen that the Minister actually gave us her account of the improvements in the way that people are paid, because I think that's also a problem if they're only paid at the end of the case, which could take forever.
Yes, thank you for the opportunity to address that, because we know from any context the timeliness of payment is so important. You talk to any small business, and they'll tell you that their ability to get paid on time is really critical. And I want to be again very candid with the committee. There are things that the legal aid agency can control, and there are factors outside our control where the provider, the legal aid solicitor, makes choices about when they're going to pay third parties. So at the moment, it is possible for solicitors to seek prior authority for certain legal aid work which encompasses forensic services. And from the legal aid end of that, we are turning round applications for prior authority within 2 days to enable that work to happen. In addition to that, solicitors can submit interim claims in Crown Court cases. We know, not least because of the delays in the court, which I'll be addressing later today at the Justice Select Committee, that many of these cases can take an awfully long time. And the availability of that route to make interim claims and get some payment and money into the pockets of forensic experts is an important opportunity. And where those claims are made by solicitors, the legal aid agency is turning that round between 1 to 3 days. So it's a snappy turnaround time. The issue arises in whether solicitors avail themselves of that opportunity, or whether, as many do, choose to pay to submit one invoice at the end of the case, which will include the expert's fee. And if that happens, then of course payment will come later. In circumstances where solicitors are choosing to do that, the legal aid agency seeks to meet payments within 30 days of the invoice being submitted, because that will be the whole of the case. And so there's probably more work to be done to go through and check it. So I guess, again, stepping back, the mechanisms we've got for prior authority, interim claims in Crown Court cases, and the turnaround time, I consider that to be reasonable, and the operational targets that we are meeting at our end is reasonable. But of course, it's not solely in our hands, because when the solicitor chooses to make the claims or put in the invoices, is their responsibility, and that we don't control. If they don't invoice and don't invoice for all the bits of the case, and there are things that are left that we need to query, that makes it difficult, and so that results in slower payment to the third-party expert.
If we're talking about the availability of forensics to the defence and the defendant, the fact that that might not be reimbursed to people within the market for a very long time because of the way the solicitors operate would indicate to me that the system's not working, even if your element of it is being dealt with as quickly as possible. I think it will be interesting to see what your investigations into how the market is feeling about this and is operating under these circumstances. All I can say is right now is my earnest hope that I do not commit a crime in the near future, because I don't think that I would be getting terrifically good advice if the person who I was getting it from was only going to be paid a few months or years later. If I said that to my garage fixer, he would frankly not play a part in the market.
Well, I'm sure the Baroness won't be committing a crime anytime soon anyway. But look, I take that point, and as I said, when I did legal aid work as a barrister, I experienced that myself in terms of the delays in getting paid. I don't think that's unusual. That doesn't mean it's a desirable situation. I make two quick points. One is, I've got to take responsibility for the bit of the system that I'm responsible for. And in that, the operations at Legal Aid Agency are good. And we're looking, but that doesn't mean they're perfect, and they can be improved on. And one of the areas that we're looking at is whether the interim payment scheme can be extended to magistrates' court cases. At the moment, it exists only for Crown Court cases. So my assessment of how we're operating on this particular point is good, but room for improvement. How can we look to make those improvements? And the second point I'd make quickly is coming back to this point about the wider transformation programme we've got in legal aid at the Legal Aid Agency on our digital systems, because again, that is going to make things easier. For so long we've been operating on outdated, clunky IT systems, sometimes having to move towards paper-based systems because the IT was failing us. That is all making life worse for legal aid providers and the experts that they instruct. If we're investing as we are, 20 million in this first year that we've been in government, with more to come on transformed IT systems, it doesn't sound very glamorous, but all of it makes this stuff tick and work better. because I recognise the point you're making. You've got to pay people promptly.
Baroness Walmsley.
Thank you. Minister, can I first of all just take you back to the streamlined reports issue? And can I ask you to really undertake to have a look at it? Because sometimes the defence doesn't even know which investigations have been carried out, because they're down to the scene of crime officer and the investigating officer. And it's very difficult to know whether any additional tests being carried out could have contributed to the defence case. So that, just leave that aside for the moment. My main question is about what you're going to be talking to the Justice Select Committee about this afternoon, about the backlog in the courts. Now, we're all aware that it's a very complex issue. There are many, many factors. But can I give you the opportunity to rehearse one particular aspect of it? And that is whether there is any role in the forensic science situation in the backlog to the cases coming before the courts, because this is a thing which, of course, we're very concerned really affects the victims of crime, many of whom actually in the end just drop out and the case falls because they just cannot live with waiting 2 years for their case to come before the courts. So it's a really important area. But what element in that complex issue does forensic science take?
And just to add to Baroness Walmsley's question, we've heard a lot of evidence about the increasing importance of digital forensic science and the complexities of the digital forensic science evidence. Is that a factor behind the backlog problem, that it's taking a very long time to analyse, to increasingly to overcome the difficulties of very extensive digital forensic evidence?
Taking Baroness Walmsley's first point, I think, given the focus that both yourself and Lord Burnett, and I'm sure other members of the committee, on how the streamlined forensic reporting is working or not, I think that what we should take away, whilst I do say that the operation in individual case level sits with the CPS, I do think we should take away within the cross-government steering groups to have this as an area of focus. So I think let's take that away, because clearly there are concerns, and obviously when your report comes out, you will share some of the detail of those concerns so we can look into the specific issues.
We'll take it away. Thank you.
In relation to the backlogs question, I almost don't know where to begin. It is hard to overstate the severity of the crisis in our courts. We talk a lot in criminal justice about the crisis in the prisons, but in some ways the crisis in the courts is no less troubling. And if we do not act, and this is what I'll be talking about later at JSC, it is going to run completely out of control. The conclusion that the independent review of criminal courts has drawn is that the system is broken. And I'm yet to find anybody in the judiciary, in the legal profession, victims of crime, or those accused of crime who've participated in the system who thinks otherwise. And I think the questions that you've both highlighted, again, stepping back, are relevant to how we've got here. How we've got here, I don't want to make a range of political points about underfunding and COVID and one thing and another. One of the driving factors is that we have not seriously invested or looked at reforming our criminal justice system since 1971, when the Crown Court was first created. And demographics, the nature of crime, and the technology governing how we investigate crime has transformed in that time. For a start, we all go around carrying one of these things. The amount of information contained on these mini computers, the advances in DNA technology and forensics, and what that allows us to do to understand whether a crime has been committed, has transformed. And with that, the volume of disclosure, the volume of information, and the expertise that's required to both help the court but also interrogate that evidence has exploded. And yet the system has been starved of funding and has not been reformed to respond to that. And so one of the big things that we see is a growth in the incoming demand into the system of caseload, but a growing complexity of those cases. So one of the things that Brian Leveson reported in his report is that since 2000, the length of the average jury trial has doubled. And that will be in part driven by the extent, quantum and complexity of the evidence that is now before judges and juries. And it's right in that context that as we look to address the immediate crisis, that we look at the broader need for reform and the approach that we're taking so that we can both design a system that is capable of meeting the demand in a proportionate and timely way, because timeliness is an essential ingredient of fairness. We need to deliver swifter justice for victims, but also one that doesn't compromise on getting to the truth and the fairness that's needed in that. And so I do think perhaps it's been a missing or underplayed part of the discussion that has so dominated the airwaves around juries and the principles underpinning that. Whether in terms of thinking of the practical arguments, a proportionate, sensible approach to digital forensic services can assist us in speeding up the delivery of justice without obviously compromising on the fairness. And it's why I think, going back to your first question about the streamlined forensic reporting, that's got to work. If it's not working fairly, then it's not working at all, as far as I'm concerned. But equally, the objective of trying to focus evidence on what's relevant to the determination of the case, of looking at, where appropriate, the instruction of joint experts as between defendants or experts to the court, things like that, that will mean that we are getting through these cases quicker in what is a new era for how we deliver justice, I think is going to be really important. And perhaps that's something that we in MOJ can take away as we consider not just the legislative reforms that are going to be necessary, but the other really important stuff, which is the non-legislative operational work, which we're doing on things like listing and video hearings and use of AI for transcription. Actually, is there a role for fairly and properly looking at the role that forensics can play to help us bring down this backlog? So again, as I'm saying the answer, very, very grateful for the question.
Baroness Northover.
Well, this follows on in terms of truth and fairness and justice, and also cost in terms of the cost of miscarriages of justice as well, not just whether things are true and fair. But one of the conclusions that the Westminster Commission came to was on the independence of the forensic science services, or lack of. And they recommended that to avoid miscarriages of justice, forensic science should be removed from police supervision altogether. And they pointed in particular to the Scottish model, or at least people have pointed to the Scottish model, where there's a sterile corridor between the forensic science and the police force. We would like your views on it. It is the case, as you probably noted, that the Home Office Minister last week was sceptical about going down that particular route. But if you are going to try to ensure that forensic science is independent, and especially the joint approach that you've just mentioned, how can it be properly independent and trusted if it remains under police supervision, who've got a particular task at hand here? Now, obviously, there's police reform going on. Are you involved with the Home Office in terms of how something like this might be addressed? And, of course, sitting alongside you, this is somebody who's got a particular responsibility to try to avoid miscarriages of justice. So could I ask you, Minister, first about your view of how you make sure that the system is independent when so much of it now is handled by the police?
Well, I take a collegiate approach with my Home Office colleague, and as you can imagine, as she is developing and prosecuting the case for police reform, in which this will be a relevant matter, we in the Ministry of Justice obviously offer our view, but we stand ready to support in this area in circumstances where, as I said, Home Office are the lead department for how this can function. In terms of independence and fairness oversight, I think that as well as the independent judiciary that oversee the way in which forensic experts provide evidence to court, the way in which that evidence is tested in court, and the credibility of that evidence, the quality of that evidence, how it's tested by opposing barristers, I think that provides a mechanism, not for the service itself, but for how we can know that evidence is being interrogated and looked at independently. The other important component in all this is the role of the Criminal Cases Review Commission, the CCRC. And I think that particularly in relation to miscarriages of justice, they have a very important role to play. Now, whilst we give our steer, they are importantly independent of government. And I think that the steps that have been taken under the new leadership under Dame Vera Baird, supported by MOJ funding to set up the Forensic Opportunities Programme, to appoint a forensic services advisor, and I believe there's further recruitment on the way, to embed that forensic science culture, if you like, within the organisation, to make the use, the harnessing of new opportunities in forensics to reopen old investigations, to test the fairness where there are alleged miscarriages of justice. I think the CCRC has a really important role to play, and because they're independent of government, they can do that with an independent lens. So I suppose what I'm saying, and I'll defer to Christina to flesh this out, is that at a point in time when the Home Office is developing its policy, developing a new model for policing in which the forensic science service will need to interact, I think we need to see how that emerges, support them in that, and ensure that it is really fit for purpose. But let's not lose sight of these other parts of the criminal justice landscape, CCRC, the judiciary itself, that I think play a part in providing oversight on an individual case level, but also at a wider level for how the system is operating and to ensure that it's operating fairly. Do you want to come in, Christina?
Yes, thank you. Just to say, in terms of the work that the Home Office is doing, our focus has very much been on making sure that the voice of the defence and the court and the judiciary is not lost in that. So we've talked quite a lot this morning about sort of parity of arms, equality of arms, and we've been very keen to sort of look at how we make sure that is reflected in the work that they're doing. Haven't specifically looked at the Scottish model, but as Minister was saying, as the Home Office go forward with their review and the work that they're doing, we'll continue to work really closely with them to make sure that it works for the courts and that it works in terms of fairness, that we've identified what needs to happen. But that's work that we'll continue to do with them rather than work that has already been done.
You might look at the Scottish model.
I'll go and have a look at it.
Thank you.
Viscount Stansgate.
I want to ask a question about evidence storage. We are, after all, in a building that's absolutely stuffed full of archives. But we're told that thousands of cases are collapsing due to missing or damaged evidence. And when we asked your colleague Sarah Jones about this last week, she did seem open to the possibility that there's a case for taking evidence storage and dealing with it centrally, no matter how many different police forces there may prove to be in future. And we wondered really whether you'd done any thinking about this, and if so, whether the idea that you might remove evidence storage, which is, if nothing else, vital to the work of the CCRC when it comes to re-examining cases and looking back at evidence that has been stored. And if you have thought about this, is this an idea that appeals itself to you and that you might support?
I think it's a great question. I think it's a great idea. I know that the Forensics Opportunities Programme that we're funding within the CCRC has written to police forces on this subject because obviously the storage and retention of forensic material, historic forensic material, is critical to the work of the CCRC and in particular this programme, which is focused on allegations, or I should say convictions of rape and murder that predate 2016. So storage is vital. And I think part of that will reveal or support the proposition that you're making, which is that we need consistency across the country in terms of the protocols governing storage, how that's done, how it's done safely, securely, and for how long. I also know that the CCRC is working with the Forensic Information Database Services to improve how you can sort of search through those databases for their purposes to identify historic cases or whatever. But again, the ability of that is only as good as the operations and the policies governing storage. So I think I too, like the Home Office Minister, I'm open to this idea. And I think if we're at a sort of inflection point where reform is happening, you know, I've described the crisis in the courts, but I'm fond of saying, my officials are bored of hearing me say it, you know, a crisis can present an opportunity. I'm not suggesting policing's in crisis, but obviously there's a reform programme there. Let's use this as the opportunity to look at something as fundamental as how forensic evidence is retained, how it's catalogued, how searchable it can be, in order to preserve the integrity of the system and enable re-investigations by institutions like the CCRC where that's needed. So good question, good idea, one for myself and my colleague to take away and see how we can develop.
Well, I think I would just say, if that's okay, Minister, that this is something obviously that the Home Office is responsible for and that they're looking at, but we'll work with them really closely to make sure that the processes and the resultant system that's put in place works for the courts and that it works, as the Minister says, to make sure that we have access to the forensics that are needed within the cases.
You've got, in your view, sufficient standing in this area to actively support such an idea in discussions you have with the Home Office?
Yes.
And turn a crisis into an opportunity. Good luck.
I'm pleased that the Viscount is adopting my mantra, because I mean I think we have to be in that position. I mean I know it sounds like politician soundbite, I suppose, because it is, but I think it's I do think that it's a useful frame for government and for government departments and individual bodies, because we can't simply, particularly in a challenging financial environment, simply just sort of paper over the cracks. We've got to look at these things. The work of this committee, I know I sort of said it at the beginning, but the themes that I that have been surfaced today and that I imagine will come forward in your eventual report, I don't want to preempt what your conclusions will be, but may say, well, look, a lot of what we identified in 2019 hasn't changed terribly much. And I think that at a point where we're looking at things like policing reform, like court reform, like changing the culture at the CCRC under new leadership, implementing the Henley Review, well, this is an opportunity. You don't get these opportunities all the time. It may be that they're being catalysed out of crisis, but so be it. Let's take the opportunity. And I think this point around storage, particularly in light of what we now know about, you will know that the technology in this area, how you store it, our ability to store it through more sophisticated databases, will have moved on significantly since 2019. Well, how does that change what you need for the storage? Do you know what I mean? Just in terms of physical space. All those things are the sorts of things that Christina and her colleagues at Home Office will be exploring and can take away from the steers that we've been given today. I think it's a really great idea.
Baroness Northover.
Can I briefly just come back on the Scottish model, because yet again, it is something that's strongly recommended by the Westminster Commission, and therefore, I mean, obviously, I hope that you read our report, and I know there are millions of reports that you might possibly read, but particularly when dealing with the Home Office, I think having a really good understanding of what they said would be very helpful, and including that.
I take that on board. I will take that away.
Lord Ranger.
Minister, thank you. It's been very good to listen to you. You have sounded thoroughly like a politician, which is good for you. But I think the challenge that I'm having is not only from the report of 2019, but onwards, whichever government's been in, these problems have been building up, and you've been in position for a while. And I'm interested when you hear, you're open to ideas, good idea over there. What I'd be expecting by now would be potentially the emergence of some kind of plan from the MOJ, especially if the Home Office are working on. I know you say you and your colleague will work with them, but what is your plan? Because from what we're hearing, there's a massive failure in the market. Costs are not meeting the requirement for the fair services that you say you're committed to seeing delivered. The technology, which has been around for a significant period of time, has not been utilised. You may revert to paper occasionally. All these things are visible to you for some time now. So is there a plan that you have already, or is there something new that you are still waiting to develop?
It's important that any plan that we develop has to work with what Home Office are planning, because they hold the pen, if you like, in terms of the funding and regulation of the service. As I've indicated in my earlier answer to Baroness Northover, I have a very clear plan for the legal aid agency in general and for legal aid funding, and I am in the process of prosecuting that plan. The biggest increase in funding for criminal legal aid for over 15 years. First uplift in civil legal aid since 1996. Most pertinently for these purposes, the transformation of the digital IT system, not only the support functions of that system, but the pathways that providers, who themselves then pay the third-party experts that we're talking about, how they interact with that system. We've got really top people, including external consultants, who are working with us to make the application process much more seamless, and that is part of my plan. So whilst I accept that that doesn't directly pertain to forensic services where Home Office are the lead and where we support in the coordinating mechanisms that Christina's referred to, it does form, it will be a beneficiary of the overarching plan that I've got for legal aid, and that is in train. Because of the cyber attack, much of that transformation work on how providers interact with the system was brought forward by 2 or 3 years. So not only do I have a plan, but that plan is catalysed and is being put into practice right now. So the experience that a legal aid provider, who then provides, who then pays out to the experts that you're concerned with, how they experience the portal and all that has changed literally in the last 6 months whilst I've been in post, because of the work we've done and because of the priority we've put on it. And that's a priority, by the way, that previous governments of different shades simply didn't place on legal aid. So I understand the challenge, and we have to await and be guided by what the new Director for Forensic Services and Home Office are setting, because we've got to be there to support them. We are an important partner, but we are a junior partner in that endeavour. But in my part of the patch, I've got a plan. I'm getting on with it.
You feel that the providers that would experience the changes that you've mentioned are actually experiencing those changes and could say, yes, they've seen an improvement?
I think if they were sat here, you would find them to be a little weary and disgruntled, if I'm being honest. And the reason being is because we've come off of 6 months of the system being shut down. But I know that the restored services, which are both restored and improved, have been tested and co-designed with the providers themselves. So accepting the very understandable weariness that they will be feeling after 6 months of contingency systems, paper, slow payments, all of which I acknowledge, and I thank them for their patience. I think if they were to look at objectively what has been built back and the efficiency and effectiveness of that, they would reflect that it is better than that which existed 6 months previous.
I have to say, I have spoken to legal aid providers, and I have heard, the views you've expressed and more about their disappointment. And I know you've made much about paying promptly, but this was a huge catastrophe for them in terms of how payments were not being made on work that they were doing, to the point that they've had to completely change their business models to not go out of business. Did you hear that from them?
I did hear that. I think it's, first of all, important to say this was the result of criminal activity. I'm not in any way drawing a direct comparison, but we've seen the way in which commercial businesses, whether it was M&S, Jaguar Land Rover, affected by similar cyber attacks and the detrimental impact that had on those businesses. The impact on the LAA was pretty catastrophic. However, what I would say is that the department and the LAA worked incredibly hard to keep the show on the road. What we did was bring before the House statutory instruments that enabled us to maintain payments. Providers could choose, and you're right, some would have modified their business model, but they didn't need to. That was a business choice for them, and I respect that. And as I said, I thank providers for bearing with us whilst we built back the system. But we enabled claims to be made for, and let's be honest, this is about supporting those providers, but the real focus is making sure their clients, the people that need the legal aid, that are eligible for it, were getting it. No one was prevented from accessing legal aid despite the whole system shutting down as a result of that attack. And I think that's as it should have been, but I'm really proud of what the Legal Aid Agency did in that time. And I now want to see how we can get the system very much back on its feet now that the IT system works. But to bring it back to your original question about, Minister, do you have a plan for this area? I absolutely do, but there's no point in writing, as government tends to do sometimes, endless reviews and endless plans on pieces of paper if I can't affect it in real life. And that's why it's so necessary to get the operational building blocks right. And it's why I've chosen, as part of my plan, build back the system, make sure it's stable and that it functions, and then we can get on with the work of working with the providers, the experts, to make sure that it's operating as smoothly as it can do. If it's not turned on, then it's not worth the paper it's written on.
Well, Minister, we look forward very much to your plan. So thank you. We're coming to the end of the session now. So thank you very much for being so candid, and we've very much appreciated you coming, and Christina also for you too. So we're grateful for both of you for being witnesses at this session. We're now going to pause for a few minutes to bring in our next panel for our one-off session on physics teaching.
Oh, wow.